Senior Mr. K.M. Joseph.
Yes, Mr. Joseph.
My lord, I noticed that my lord had gone through the text already of the judgment.
On the occasion when you are not here to assist us.
Yes, I saw that one. My lord, I had gone through the whole thing. My lord, may I come to page number 15. My lord, this impugned judgment has two parts. One is from page 1 to 15, where the court has detailed all the facts of the case, which really shows that the child, the boy, the son of the petitioner,
Yes.
was disturbing the classroom, burst a cracker, and injured a handicapped boy, and the children who reported it were all beaten up by him. And then parents, when called, refused to even to apologize or to assure that the child will behave well. And there was a lot of problems. These are all well documented.
Yes, Mr. Joseph.
My lord,
Now we
after
find.
that,
No, just a minute.
my
Just-
only complaint is
Can you-
about
can you-
paragraph 16.
Can you just listen to the court for a second?
Yes.
Now we find that the learned single judge meandered
Yeah.
from this side to that side, which may not have been necessary, but that was his perception. Now, as on date, there is no castigation on you.
Yes.
There is nothing. There is no castigation on you. You are not dubbed as a bad school. You are not shown as a bad principal.
My lord,
Now the direction is to the government.
Yes. My lord,
So therefore, why have you preferred an appeal? You should have kept it under the wraps. That would have been better for your institution.
yes, it would have been. My lord, only thing is, I myself, the principal, is already an awardee from the state government for the best principal of this district. My lord, my only complaint is that, of course, my lord, I noticed that this is an old matter.
No.
And
We are not looking at it from that angle. Old or new doesn't matter to us today, because it has come before us for adjudication. The difficulty is that the court is not finding any list to adjudicate. You have been asked to do nothing.
Yes.
The expulsion of the student has not been interfered with.
Yes.
Right? So therefore, for all practical purposes, you have only shown your displeasure because of your being told that you're not a good principal. That's all.
Lord,
Right?
my
But
name is spoiled.
let me be fair to the learned single judge. He has not dubbed you as a bad principal. The ball is now in the hand of in the court of the government. Now let us ask from Mr. What have you done?
My lord, only state is we have complained it's only against state. My lord, however, my lord, being told, I am ready to withdraw.
The state was a party. The district magistrate, just a minute. District magistrate made an inquiry. What kind of inquiry we don't know, but he found that you were at fault.
What kind of inquiry?
Now we are not concerned with that. Now let us not take it to any further level, because you are a school.
Yes.
Many students study in your school. If your school gets a bad name, the students get a bad name. Therefore, we are not saying anything here.
Yes.
Now, since you have not been directed by the court to do anything further,
Yes.
I think You ought not to be,
Not to
you
press
ought not
it.
to feel
Okay, my
aggrieved.
lord.
Don't press this.
I will not press it.
Don't press this.
Okay.
Mister, but however, since the matter has come before our eyes, we need to ask them. Now, read para 24.
Yes, my lord, in terms of para 24, my lord, there was a direction for preparation of the exhaustive guidelines for the minority
Have you done
institutions,
that?
my lord. My lord, that has not been, my lord, done, my lord. I have talked to the authorities, my lord.
That was the prime responsibility
Yes,
of the
true, my lord,
administration.
true.
Just for the reason that you hold an inquiry against the principal and you don't say the reasons, and you find that the principal was really wrong in expelling a student. When you make that kind of a statement, then you be ready for coming out with a guidelines.
But
It was a positive
there is
direction to you.
guidelines, but not with regard to the minority institutions, my lord.
We are not concerned. Minority or non-minority, section 272 has been quoted. Have you read that?
Yes,
It's a government, it is a government aided school. Minority but government aided.
my lord.
So therefore, you have to leave them the freedom, you have to give them the freedom to administer their affairs. But so far as discipline, maintenance of discipline is concerned, you can. But this is not, argument is not to be had on Article 30 here, Mr. Sarvesh Kumar Singh.
My lord.
That argument is long gone. Today is not the day when you would argue that.
But
क्या करना है बताइए?
that has to be done, my lord. Sometimes may be given, my
Mr.
lord.
K.M. Joseph.
And a direction be
My lord, on
issued.
that I would like to submit one, that section 18 does not empower the government to interfere in any way with the day-to-day administration.
Forget about that. Now,
Day-to-day administration.
once they come out with the guidelines, you challenge it.
My lord, one more. That I
Once
will
they come out with the
actually
guidelines, you challenge
Yes.
it. Now we will
My
say
lord,
something which will
another
just a
point
minute.
is-
We are not giving you. We are not. You are not. Simply burying this appeal.
Yes, my lord.
But we are giving a decent quietus to it
My
by
lord,
recording certain things.
May I just make one observation? My lord, this whole thing, when my lord sees the report, it is based not on the facts,
But I must tell you-
because repeatedly these
That's all right.
officials have been insisting
It's all
for
right,
admissions.
Mr. Joseph. Now kindly hear something in lighter vein.
Yes,
Now you as a you're wonderful as an advocate, but you as a teacher was very strict, which is the experience of the court.
yes, my lord.
I was a student of your. I was
Yes,
the student of a
my lord,
school
I
in
know.
which you were teaching,
Yes. Yes,
and you were rather strict with the students.
I was teaching there, yes, my lord. Thank you.
But it was not that school. The school was different. It was St. Michael's High School.
St. Michael's I was teaching and I was doing well, but I came here precisely to defend the poor people.
I think
In that
I
case
think
only I
you
came.
were there when I was a student.
Yes, my lord.
Like you heard Mr. K.M. Joseph, learned advocate for the appellant school, and Mr. Sarvesh Kumar Singh, learned additional advocate general number 12,
13.
number 13. The controversy arose when a student of St. Xavier's High School was expelled for having exploded a cracker in the school premises, which had led to injuries on one of the differently abled students of the school. The expulsion of the student was challenged by his mother, which led the learned single judge to inquire into the matter in some detail. However, in detail, the district magistrate Patna was asked to find out
Yes.
and fix the responsibility, and the report submitted by the district magistrate was not favorable to the school management. First off, be that as it may, the learned single judge, finding that much time had elapsed, did not direct for reinduction of the student, but as part of larger social measure, directed the Principal Secretary Education Department, Government of Bihar, to come out with exhaustive guidelines to be followed strictly by minority institutions without interfering with the rights of minority institutions to establish and manage their institutions as envisaged under Articles 29 and 30 of the Constitution of India. First up, it was expected by the learned single judge that the government would take necessary action in that regard as contemplated under section 18 of the Bihar Non-Government Secondary Schools takeover of Control and Management Act, Act 1981. Stop. Mr. Sarvesh Kumar Singh, the Learned Council for the State, however, submits that till date no such guideline has been prepared. Stop. However, we find from the impugned judgment that there is no castigation on either the institution or the principal of the institution or on the running of the institution. Stop. Since there is no list to be decided in this appeal, we consider it appropriate to give a quietus to the entire dispute, but with the caveat that the direction to the state government and the authorities to come out with guidelines still subsists, which they are under an obligation to frame. The records of this appeal are thus consigned. The appeal is thus consigned.